Hello everyone, this is Tutor Angus. I'm with Delegates. Welcome to our panel discussion. We're about to get started with our webinar. Our topic today is, are you endangering your IP assets during a transfer of rights? Submit your questions throughout the webinar. We'll dedicate the last portion of our discussion to answering everyone's questions. Anything left unanswered will be returned to you by email after the webinar. And also wanted to note for everyone that the webinar is being recorded and we'll make the content available to everyone after the session's over.
Thank you, Tutor. I'm Sharon Schaffner-Meyer, Managing Director, Americas for Delegate. For those of you who are not familiar with Delegate, we are an attorney-assigned IP administrative services company. We provide IP administrative services for IP attorneys in corporate legal departments and law firms. Delegate is our new brand name and is the combined
Muted.
Yannick Byron is our Chief Product Officer at Delegate. Yannick is a seasoned French and European patent attorney with vast project and risk management expertise. Yannick is an integral part of Delegate's leadership, where he focuses on our team's deliverables through quality control, process optimization, and he also oversees our exciting new product launches. Mark Kroll is Senior Advisor at Delegate. Mark is a thought leader in IP, and he's our Senior Advisor at Delegate, where he uses his vast experience in intellectual property to assist our leadership team with key business decisions. Mark was the Vice President, Intellectual Property at Illinois Toolworks, where he was responsible for identifying, capturing, and enforcing the company's proprietary new technologies. Mark graduated with his undergraduate degree in mechanical engineering from Bucknell University and his JD from DePaul University College of Law. Kenneth Ng is U.S. partner at Chang Sai & Partners. Kenneth has been with the firm of Chang Sai Partners since 2014, where he is now oversees client relations and North American case management. Kenneth is a former Chief Trademark Counsel at Kohler and Illinois Toolworks, and his expertise ranges from mergers and acquisitions to IP enforcement, domain name disputes, and budgeting. Philip Price is an associate at Danes. Philip is a chartered and European patent attorney at Danes' office in Brighton, UK. Danes is one of Europe's most prominent IP firms, where Philip is focused mostly on the biotechnology, pharmaceutical, nutraceutical, cosmetic, and veterinary science fields. Phillips offers strategic advice, mostly to SMEs, while also focusing his work on portfolio analysis, patent drafting, and prosecution. Cindy Schermerhorn is an IP manager at Astellas US. Cindy Schermerhorn currently oversees a large portfolio of rights as IP manager for Astellas, a large pharmaceutical in Northbrook, Illinois. She has 25 years of IP experience, which has mainly been in patent prosecution. Cindy is well versed in both U.S. and international patent law and has worked with both law firms and corporations throughout her career. So I want to thank the panelists for your participation, and I look forward to our discussion today. Our topic today is on recordals, and it's part of our IP exchange series, where we pick a topic related to IP and bring together a panel of experts to discuss those important issues related to this topic. Following today's discussion, you will not only get a link to the recording, as Tudor mentioned, you'll get the full bios of the panelists, and you'll also get a checklist to assist in your project approach as you transfer IP rights. Now, why recordals? So we picked recordals as our first topic for our IP exchange series. We actually went out to our current clients and prospects and did some market research on what topics you would find most interesting. One of the topics that came back was IP recordals, and the market feedback, we asked, to what extent do you agree or disagree with this statement? I am confident in my ability to advise my client or leader on global recordals. And you can see that almost 75% of the participants, we had 177 responses, disagreed or strongly disagreed that they are confident. And when we asked why, if they disagreed with that, if they were not confident, and we asked why, they gave us an open-ended answers. And then this is a word map of why these particular projects are extremely difficult to manage. So what we've tried to do is take that feedback and create a panelist discussion that really addresses some of the issues that you said were most problematic. So at this point, I'd like to turn it over to Mark Kroll, and he's going to really talk about the importance of a good plan. Mark?
Muted.
Hello, everybody, and it's a pleasure to talk to you about one of my favorite subjects, that being recordals of IPs, of IP rights. And I think if you look at this slide and the next slide, the first questions you ask are, is a recordation needed? And then the second thing we need to look at is looking at the project scope. So looking at the next slide, possibly let's start with identifying when we really need to record an IP transfer. And these, we've listed a few here. One that, of course, we all know about is making sure that the assignment of an invention from an inventor to the corporate employer is, at least in the U.S., is listed and is assigned and recorded. But the other big issues that come to my mind, and has been in my experiences, are bigger projects such as in mergers and acquisitions. And of course, there are two flavors of mergers and acquisitions. One is a stock deal, and the other is an asset deal. And I guess the first thing we need to know is the deal going to be a stock deal or an asset deal? Because the timing and issues for each of those differ. For example, in a stock deal, it is possible that there is no there's no assignment of specific assets, but there's just purchase of all the stock of a target company. But even in those situations, it's been my experience, the new company's legal department or accounting department wants to change the name or do some corporate restructuring of the new companies, and that would require then a recordation of all the assets that are owned by that company. So even in a stock deal, generally shortly after the acquisition, there's a need for a recordation project. And then the other type is an asset deal, in which case then the assets are being purchased at the closing, and it is, to me, it becomes very important that then the recording of that asset change is done on a timely basis. And of course, here in the U.S., we want to get it done within 3 months. So it needs to be done. It needs to be in the front of mind, I think, of the IP department, and the IP department needs to sell the importance of that to other people within the corporation or your client. As we talked about, any change of company name requires a recordal, any change of address, or any change of when a change or a license recordal. One example is another time that we found is when IP assets are part of a tax planning strategy in which the IP assets are moved from one corporate entity to another. And again, I think it's important that the IP department or you advise your client that a client corporation that they need to be sure to have in their budget that there will need to be a recordal event in this planning. And finally, there may be an exclusive licensee may be interested in recording their license in order to be able to gain an infringement action from from the IP owner, if not launch the action themselves with the owner's consent and claim compensation from an infringer from the date the license has been recorded. So, so it's always interesting to me that, and we can look at the next slide, that, you know, here we are as IP attorneys working with the most creative people on the planet, I think, and we're dealing with assets that have long-range importance, and the protection of those is done with something as mundane as a filed document and all the attendant ministerial duties that are related to that. And so, so with that project, then if we go to the next slide, we need to look at what are some of the, let's looking at it from more of a project management point of view. And the slides with a slide here with the sort of the 4 stages of the project, where we look at the project scope, situation analysis, the document preparation, and the execution and reporting of the assigned recordal documents. So, and just reviewing these briefly, you know, one in the project, how big is the portfolio and what is the urgency? Again, this sort of relates to whether it's a stock deal, if it's a merger and acquisition, or it's an asset deal. And then early on, you want to establish a team and work, and in my experience, get a cross-functional team, which includes the deal attorneys and the accounting, somebody in the accounting department, so that they can appreciate that one of the main things that is being purchased in an acquisition is the IP and the importance of having it recorded and the ownership fully vested in the buying company. Then looking at the situation analysis and the document preparation, you can read those, and then I guess at this point in time, I think it would be interesting to get from Phil more information on the timing of doing some of the due diligence from the purchasing attorney's point of view, on how he advises his clients on when to do and how much to do due diligence on the existing IP.
Thank you, Mark. So when we're talking about due diligence, obviously that needs to be done well in advance of the execution of any transfer. And the question here about how do you advise your clients, in particular those acquiring the rights, about knowing who the owner is. And when we talk about ownership, we need to distinguish between the actual owner and the registered owner. So that's the owner that's actually listed on the registers of the various patent offices worldwide. Because the actual owner, of course, needs to be the assigner or licensor in the transfer document. But since the filing of the properties that are being transferred, the actual owner may have changed or may have changed name in the past, and the registers may have not been kept up to date. I think it's probably likely that they haven't been kept up to date. We see this very often in recordal jobs, that a portfolio of cases is being assigned and the cases all have a variety of different registered owners. So that is an issue when the actual and registered owners are not the same, because it makes the recordal process less efficient and more complicated for the assignee, because the assignee will need to evidence not only the assignment that they were party to, but also the entire chain of title between the registered owner and the actual owner who was party to that assignment. And obviously that's very difficult when they weren't involved in those earlier steps. So a practical tip I'd give to assignees and licensees at the due diligence stage would be to ask the assignor or the licensor to ensure that the registers are up to date for all of the properties that are being assigned or licensed, and then that will leave the assignee with only one step to record, which is the step that they're party to. The question here also asks how they might go about finding who the owner is. Obviously for the registered owner, you can use online registers, you can contact patent offices and local attorneys. In terms of the actual owner, you of course need to rely on the internal due diligence of the assigner.
Thank you, Phil. That's very interesting. And then we're also I guess we've done our due diligence. We think this again, I guess from the buyer's point of view, we've checked to make sure that the spreadsheets provided to us by the seller matches with what the records are in the relevant patent or trademark or copyright offices throughout the world. And then we're getting closer to looking at the deal agreements themselves. And so I guess the next question would be to Ken, and what do you like to see in the master agreement or the big deal agreement, and duties to follow up and some of the budget issues?
Hey Mark, can you hear me? It's Ken.
Yes.
Oh, great. Well, ideally in the master agreement there is language to have such agreements signed as of closing. In my experience, and I've been on many deals, it is not always possible for that to happen, either from a timing standpoint or just internal politics. It can't get it happen, and in situations like that, or if IP counsel is pulled in too late and there's no opening for the master agreement to reflect such assignment, then some form of clause that allows parties to cooperate post-closing is highly recommended. The assignment process, as Phil may have alluded to, can be complex. You may have different entities on title, and typically the chain does have to follow the parties on record versus the parties on paper, and those have to be aligned, obviously, for assignment to occur. So ideally, just to sum up, the documents, the assignment itself is the business agreement, agreement. otherwise a cooperation clause for assignment documents to be signed post-closing.
And in an asset deal, is it sometimes would it be possible if you've done your due diligence, you have the and you've got the master assignment within the multi-page purchase and sale agreement, that if possible, can you try to get in the closing room then a set of single-page country-specific assignments that the SNR can also sign?
It is possible, although that's ideal if we can get that, and that's always the high watermark for what we strive for in every closing. However, that's, in my experience, is incredibly difficult to achieve given the variability of conditions from country to country. For example, in China, you need to sign not just the assignment agreement, but powers of attorney associated with the assignment. There are various documentary requirements per each country. Language issues, so translations, not just China, but other countries as well. Ideally, you can get them all signed on closing. Depends on the company, how quickly it closes, how quickly you can verify ownership and get documents before get the accurate documents before the relevant people for signature on the day of closing.
And then also maybe we can talk a little bit about who pays for the recordal project, the seller,
Yes.
Generally the seller or the purchaser? Yeah,
that's a great question, Mark. Again, in my experience, assignments in some countries like the United States are quick. They're relatively inexpensive, and it can be done. In my experience, in corporate transfers, there are various entities involved: asset deal, stock deal, assets in the name of a holding company, and assignments, if it's a large portfolio, it happens around the world, is a slow trickle. It's not a quick project. It's not like recording your house at the record of deeds where it happens in a day, a week, a month. These assignment projects can take up to 2 years. And a budget for that, typically the assignment budget is closely associated with the deal budget. Well, the deal budget closes very shortly after the deal closes. And if the assignments continue to trickle through, the budget for assignments runs dry. This can leave outside counsel, vendors in the lurch. Who's my client? Who's paying for this? And so my approach to this in the past has been to reach out to the vendor, give me either a fixed price or a reasonable, not to exceed estimate on how much this assignment process will take. Bill me, set up an escrow, and out of this account is where all the assignments occur. That way the whole project is handled as one, out of one budget early on, as perhaps a component part of the M&A deal, and there should be no issues after that with respect to billing. This can simplify for the vendor, also for the client, who's the client, which the budget it is, and have these taken care of.
Yeah, I agree with that 100%. And I guess from an internal corporate point of view, it's also interesting to me that from a buyer's point of view, generally they are the ones that are very that have the most at stake in making sure the recordals are done and done properly. So they have the primary responsibility. But then, whose budget should this be on? Should this be part of the deal budget or part of the IP department's budget? And
yes,
I think if the IP department can get to the accounting department early in the process and explain to them that part of these costs can be then associated to the purchase price and then amortized, that then a lot of these costs can get out of the IP department's budget and into the purchase and sales the budget for the acquisition itself, and then so that it's not, the IP department is not burdened, at least for the first year, or as long as you can keep the deal budget alive in doing this, or setting up the escrow like you suggested.
Yeah, that's really a great point. And I guess the one takeaway from here is that IP counsel doesn't always have visibility for deals. Having been in-house for a long time, as you know, Mark, if you get visibility of the deal, what we're talking about is fairly easy. You figure out who's paying for who early on, and it gets resolved. Very oftentimes, in my experience, IP counsel is surprised or is not given a lot of time to figure out who pays for who. And the other component here is that the person leading the deal is not familiar with these requirements. And the more they understand about who pays for the assignment costs, the more they might not be able, they might be able to help the purchaser company or the seller company, whoever we were working with, to say, well, typically the obligation falls upon the buyer to assign, and the seller shouldn't have to pay for the assignment of the IP rights.
That's great. Great advice. I agree. Maybe we can skip to the next question with issues concerning ongoing litigation of any IP that is in the midst of this of the deal.
Yeah. Do you want me to speak to that, Mark?
Yeah, if you could.
Yeah, sure. It's really important to understand, say again, with a large portfolio, is there any litigation, and does the litigation currently hinge upon or even refer to any IP rights? These can trigger issues that go far beyond assignment. If you have patent or trademark litigation involving a particular right, who's the owner of that right? And what evidence does the court need to see to assure that there's clean chain of title? The assignment of such rights can disrupt litigation and even change its course if you're not familiar with local rules involving such transfers in that jurisdiction. So, without focusing on any one country, I can say that with experience, these things have to be looked at in detail with local counsel on the ground during due diligence, ideally if possible. The first thing to note here is, if you are aware of a deal, one of the first few things you should do at due diligence is to look for litigation. What litigation is pending? Is it related at all to IP? Which IP rights? And what are the documentary requirements for proving up such IP rights, or what has been done or what needs to be done? And how does a transfer impact such litigation? That's one part. The other part, and Mark, something you know a lot about too, is the question of damages and how damages may or may not be affected with assignments, particularly if there are licenses involved, whether they're internal licenses or external licenses. So IP rights bring with them a lot of complications. In really complex cases, this may even change the structure of the deal.
Yep, absolutely. And not only damages, but also possible injunctions, concerning, patents or trademarks in particular. But so thank you.
Sure.
So, let's keep moving here and get to Yannick, and and maybe you can talk a little bit more about some timing, Yannick, and when do you recommend a quality check for a chain of title on relevant assets?
Well, thank you, Mark. This is Yannick calling from Brussels. So just to come back actually on the different points that were mentioned, actually I fully agree with Phil's point of view, and we should do this as early as possible in the process. And bouncing back on Ken's comments, I think also for a buyer, if you're a buyer and you want to acquire a company or acquire IP rights or part of a company, I think the basic thing to start with is to make sure that these IP rights belong to the seller. So of course you can plan a clause a guarantee clause in the contract to make sure that of course all these IP rights belong to the seller. But something very simple to do and quite straightforward to do is a data verification process, which will anyway be necessary to record all these IP rights in the new name, in the buyer name. So I think performing this data verification step is a very simple and efficient way to check before going into the closing room that as an IP attorney, when you want to make this deal, the IP attorney is involved or a vendor is involved to make sure that all these IP rights belong to the seller. And just the starting point is just doing this administrative check. And actually for delegate, we just focus on this administrative check. So we won't check if there are other assignments which are not recorded, which may be applicable on the IP rights. But at least the data verification process on the register tells you whether all these IP rights appear to belong to the seller or not. So I think when you do this early just to make a preliminary check, it makes sense and it will help a lot for the whole project, because when you are able to prepare very accurate confirmatory assignments, because what happens in master agreement where you annex or attach confirmatory assignments, what happens is that these assignments will generally and most probably not meet the legal requirements of the jurisdictions targeted in the portfolio. Because these legal requirements are very specific to each jurisdiction, and there are really simple things like in Italy, they wouldn't accept documents being signed in counterparts. If you don't know this from the start, then you sign this in counterparts, and then you can. There was no point in having everyone in the closing room because you have to send this back to all the signatories to make sure this document complies with the local rules. So having this data verification process upfront allows you to prepare all the relevant confirmatory assignments. Associated to these confirmatory assignments, you can prepare a very detailed legal requirements, how these documents should be executed, what are the requirements in terms of authentication, in terms of notarization, legalization of documents. And also you can join to these confirmatory assignments, like Ken said, these power of attorney forms, which are generally required for all the attorneys in charge of the recordal to perform these recordals in the name of the new owner. Because all POAs which were applicable before in the name of the old owner are not applicable anymore because you will record a new owner on each register. So I think it's really important, coming back to your question, Mark, that we do this as early as possible. I fully understand the issue about the timing at the closing stage, but I think this should even happen before even this, because when you start being interested in a company, you should be looking first at what are these IP rights, does the company own IP rights, and whether these IP rights belong to the company before you start investigating whether you want to acquire anything. So this is my first point. And when I'm making a transition, maybe to Phil, who I think would like to talk about European specificities. This is really dependent on each jurisdiction, and each jurisdiction around the world have their own rules for recordals in general, and this is really important to understand them straight away. So I let Phil, if you want to continue on the European specificities.
Okay, thanks, Yannick. Yes, we could move the slide on. And again, there we go. Yes, so as Yannick mentioned, there are some unique issues for transfer recordals in Europe, and that's mainly due to the fact that applications are filed and examined centrally at the European Patent Office in a single application. But once that application grants, you don't get a single European patent, you get a bundle of national patents in the European states of interest that you validated in. So that has some practical consequences for recordals, and I will mention those on the next slides. But first I thought it would be worth touching on why recording transfers is worthwhile, and we've heard quite a lot of that already. Obviously, keeping the registers up to date makes subsequent recordals more straightforward, and the patent offices are going to communicate with the registered owner or their attorneys, so it's important to keep the register up to date so that you get renewals notices, etc. But this slide contain some of the sort of less commonly encountered reasons for recordal, but they're still important. So firstly, recordal protects against subsequent good faith but erroneous assignments or licenses taking precedence over your assignment or license. So for example, if you are an exclusive licensee and you do not record that exclusive license, and for one reason or another the patent is licensed to another third party, that shouldn't happen because of your exclusive license. But if the second assignee records their license, so that the second licensee records their license and you did not record yours, then you can't prevent their license from taking precedence even though it's inconsistent with yours. And that's quite an unusual situation, but there have been cases where that has happened. Recording yourself as the owner or exclusive licensee also clearly establishes yourself as being entitled to bring infringement proceedings. That's a fairly obvious one. And also in relation to infringement, this is in the UK now, if you don't record your assignment or exclusive license within 6 months of the date of execution, then you lose the right to costs and expenses in any infringement proceeding where the infringement occurred prior to the recordal. The situation in the UK used to be more severe than this. You used to not be entitled to damages. Now it's limited to costs and expenses, but obviously that could still be quite significant and is certainly more significant than the cost of a recordal. We'll have the next slide now. So in terms of the practical points in Europe, it's important when you're doing due diligence to determine the status of the European cases. And that's because recordal of a pending European application is a lot more straightforward than a granted case. So for a pending European application, you can record the transfer at the EPO, use the agent's record or the assignee's agent, and you do need evidence of the transfer, but a simple copy of the assignment document would suffice. There's no need for certifications or notarizations. The evidence that you submit definitely does need to demonstrate that the transfer took place, so evidence of an obligation to transfer won't be considered sufficient by the EPO. Recently, the EPO has tightened its requirements slightly, but it's still very straightforward to record assignments at the EPO. Although Article 72 of the EPC did always state that an assignment requires the signature of the parties to the contract, the EPO's practice used to be that you could record an assignment with only the assigner's signature if the request was made by the assignee. But that's changed, and now you do need both signatures on the copy of the document that you submit. You used to be able to indicate that the position of the signatories simply as authorized representative, but now the EPO wants to see the precise job titles of the signatories in order to check that they are actually authorized to sign on behalf of the parties. So slightly more onerous than it used to be, but still straightforward. Whereas if we look at granted EP cases on the next slide, then things get more complicated, more burdensome. After a European application grants, you will choose the EPC member states that you want to validate in, but there will be a 9-month period from the date of grant where the patent can be opposed at the EPO. If you record the transfer during that opposition period, then you can do so at the EPO. And some, not very many, but a few European countries will automatically update their registers because you recorded that at the EPO. The EPO will also issue a communication stating that the transfer has been recorded, and that communication can be used as evidence to record the transfer in most but not all of the other validation states. So that does simplify things slightly. The other thing to note about recording transfers in the opposition period is it is limited to transfers and not licenses. The EPO won't record those in the opposition period. And then after the opposition period expires, if you want to record a transfer, then you cannot do it at the EPO, and you must record it at each of the separate patent offices in each of the validation states. Now that is where things can get burdensome, because there are 38 EPC member states which you may have chosen to validate in, and they all have different requirements in terms of the evidence that's required to record the transfer, the certification, notarization, legalization, etc., and whether or not powers of attorney are required from the assignee. I'm afraid there's no consistency between the validation states there. We've been speaking about transfers, but recordals of changes of name, the requirements are broadly similar to the requirements for recording an assignment. And in most countries in Europe, the changes of address do not normally need to be evidenced. They can just be requested. But I'm aware that that's not the case in all countries globally. Addresses can be significant. So in summary there, when performing due diligence, identify the status of the EP cases, whether they're pending, granted, and in the opposition period, granted and outside the opposition period, and also identify which validation states have been selected, and whether, of course, whether or not the renewals are up to date in those validation states as well. And the final slide that I wanted to mention, which isn't directly relevant to recordals as such, but is relevant to the due diligence tasks in any transfer, is that when you're performing due diligence, it's important to identify cases that could yet serve as a priority application. So in the normal course of events for patents, that would be cases filed less than 12 months ago. Once those cases have been identified, keep a very tight control on the date of the execution of the assignment relative to the date of any subsequently filed application that claims priority back to those applications. And that's important. And what you really need to avoid there is a priority application and a convention or, for instance, PCT application being filed in different names if an assignment of the right to claim priority hasn't been executed before that subsequent convention application was filed. And that's because the Paris Convention, the EPC, and the UK Patents Act all require the priority claim to be made by the first applicant or their successor in title, and that's assessed on the date of filing the convention application. So if your PCT application lists different applicants to your priority application, and that no assignment of the priority right is in place, then the priority claim is invalid, and that can have obvious negative consequences. There's an infamous case in the UK, Edwards Life Sciences versus Cook, where this happened, and the certain claims were deemed invalid because of a loss of the priority claim and some intervening prior art. And I've also mentioned here that the EPO takes the same approach, and a recent case that came out this year concerned the situation where the priority and PCT applications were filed in different names. The assignment document was executed after the filing of the PCT and referred to the assignment having an effective date that was before the PCT, and the EPO decided that that did not overcome the problem. So the assignment document absolutely has to be executed before the PCT application is filed. And that's a very important lesson. So there's some European specific aspects, and I hope now to hand over to Ken, who's going to talk about some specific issues for China. Ken.
Yes, thank you. I appreciate it. I'm just pulling up the slide. So recordals in China, I represent a Chinese firm. Just general points here. Assignments in China are not quick. There are multiple forms to fill out. You generally do not need the assignment agreement. However, they can be they can take up to a year to complete. They have to be filled in Mandarin. The transfer of rights will essentially trigger a review of all rights associated with that company. So in the case of a large deal, or in the case of a small company, it's helpful in due diligence to check to see what rights have been, what rights are being transferred to understand. So to give you an example, if you're dealing with a small company, it's not unusual for some IP rights to be the name of the founder versus the name of the company or the founders. In a large company, it's not unusual for IP rights to be in a subsidiary, a defunct subsidiary, or a subsidiary that incorrect subsidiary, simply because IP was sold but never recorded, or a company name changed and nobody recorded it. The second point on my slide can trigger problems during assignment, because it basically creates an audit by the office to ensure that all rights are moved in a bundle. This also means that it would have to be budgeted for and paid for all at once. The third point are, generally speaking, again, the documents that will be needed: the powers of attorney signed by the assignee, the certificate of good standing, and the certificate of merger. This is a labor-intensive process in China. There's no one master agreement for all IP rights. It's one application filled in for one IP right, unfortunately. And so the bigger your portfolio, the more expensive this becomes. Again, working with a vendor like ValuePat would give you a global cost of this process and would be able to simplify this process for you.
Thank you, Ken.
Sure.
And now I'm going to turn it over to Cindy Schermerhorn. She's going to talk and come at it from a project management perspective. What are some of the important elements? Cindy?
Okay, thank you, Sharon. As far as paralegals are considered, we do the administration part of it. And most of the time, I have sometimes here, but in fact, it's actually most of the time, we are the last to know about a purchase or a merger. So my suggestion to anyone would be to bring the paralegal in as soon as possible. Because we can get the documents started, we can get legalization started, we can order the good standing and the certified copies that are needed. We can track down inventors if we need signatures. We can, at least ask the old owners for information regarding inventors and things like that aren't always brought up, and it takes longer than after the fact than if we could do it at the beginning. Once a closing has occurred, then officers of the company or the signers of that company are gone, and new ones have not been elected. In several cases, and my past experience was that it would take a couple months before new officers or signers could even be elected by the company, the current company. So it's important that with some of these that the assignments are done quicker than postponing. Next slide. So the steps that I usually take is I reach out to the foreign associates and ask them for the papers. If it's a small portfolio, I can usually handle it and get everything ready and going. Prepare all the papers for each of the countries that are listed, getting the list of countries that they're actually in so that you do know a good inventory. Sometimes that's not necessary or it's impossible to get, and even though due diligence has been, I've had times where countries pop up that you never even knew existed. So it helps for the paralegals to get in there and kind of do their little background check also. And I keep organization with, usually it depends on the size and what the case is about, but I try to put my countries in order so that I know what is needed, and I have a list of spreadsheets that tells me what stage it's in, if it's out for signature, or if it's out to the associate, or if it's, we're waiting on something. So I have a detailed spreadsheet that I keep track of everything. If it's a large portfolio, I usually reach out to a outside service to help me. It can get done quicker and a lot more logical. So that would be my.
Thank you, Cindy. Appreciate that. And now, now that we've heard from Mark, sort of setting up the project, the importance of all the elements, we looked at some of the nuances from Philip for Europe and Ken for China, and Cindy talking a little bit about, from a perspective of the paralegals, how you pull this together. And now I'm going to turn it over to Yannick, and he can bring it all together. Yannick?
Yes, thank you, Sharon. And actually, thank you, Cindy, because what you explained is exactly what we can offer as a vendor. Actually, what we do is exactly what you do, but we do it instead of you. So, and we try to, because we focus all our time on handling this type of projects. When I imagine you can tackle other types of IP issues on a daily basis. We just tackle these projects every day. So actually what we came up with is really a kind of methodology which tends which helps us actually and help our clients anticipate on all possible issues that can arise with these IP recordals, including, as we mentioned already, document issues, understanding the legal requirements, understanding the required POAs, representation issues, which can be a problem, as I mentioned, when you transfer rights from a company A to a company B. Then indeed the attorney who was appointed by company A is not the representative in most jurisdictions after the recordal has been filed, because now the titles are in the name of company B, and therefore the power of attorney from company A is void. So these are all important things to consider actually as soon as possible. And this methodology that we've developed is actually focused on all this anticipation. The first phase actually, which is on the left-hand side here, we call it the assume phase, because in the beginning of any project, actually what our clients request is really predictability and transparency on costs. We can prepare quotes in a matter of hours, so this is really, I think, a very important added value for our clients. Sometimes, as Ken mentioned also, we want to receive information in very short time frame, and actually we have agreed with our network of agents on specific fees for managing these projects, and we are able to generate quotes in hours. The problem with this is that, of course, we want to then to align what is actually required for the project, and this can include possibly changing the agents if other agents should be involved, or if other agents should be appointed. You can imagine a company A selling to a company B, and actually they are both competitors, but maybe company A wants to divest some of its a part of its company, and therefore selling to a historical competitor, which is not a competitor anymore. And in that case, company B wants to appoint its own agent and does not want the previous agents of company A to keep handling the prosecution for them. There are obvious conflicts of interest to consider. So all these kind of things are things that we want to clarify from the beginning, And initially, we don't know about all this, and we prepare what we call a preliminary quote with a series of assumptions regarding the agents, regarding the status of the IP rights on the worldwide registers. So what we do next, and actually we cannot do anything more than this until we perform this data verification process. This is what we call here in orange the analysis phase, where actually we will collect all available information from the client, basically information on what are the supporting documents available, maybe the master agreement, if we can have a copy of this, or even if it's blacked out, so that we can see the names and the parties involved. And based on this, we send to our agents instructions. Our agents are actually IP firms all over the world who are familiar with performing this data verification, and actually what they do is compare what is on the registers for each IP right listed with the information mentioned on the preliminary supporting documents. And from this point, we know exactly actually what has to be recorded, because we have the starting point for each IP right in the list, and we can therefore identify all the different steps that must be recorded for each IP right in the list. And only then can we provide an updated quote, which is an updated cost estimate, if you want, with the relevant steps. We know the agents who will handle the recordal. We have a very clear picture on what supporting documents should be used. We know the legal requirements. Everything is cleared. And then the only thing that we need is basically getting these documents executed by the client, which is the end of this analysis phase. And sometimes I'm asked about the timing for recording these big portfolio projects and recordals, and actually sometimes it's difficult to obtain signatures. So then these are things that are independent from our will, but sometimes we cannot find an inventor, we cannot find a signatory, a representative, for example, of a company which has disappeared. It's something where we may have difficulties. So now we've come up with specific alternatives, typically notarial declarations or affidavits that we use depending on the jurisdictions to deal with this kind of issues, which happen quite often in the end. Once we've received actually the executed forms, this is actually the very straightforward part of it, because we know that all these forms comply with the local rules, and then we will just check that these forms comply with these rules, send them to our agents who just file. Then we collect, and actually we do a lot of work at this stage by coordinating the work of all our agents worldwide, just like during the data verification and the previous step. And we centralize actually all the filing reports, all the invoices from agents, and for the clients, basically they receive one invoice or coordinated at least invoices, because if you have different chains, typically we will handle these chains one after the other, and you could the client receives one report with each chain and the corresponding invoice. At this point, we are not closed yet, because we need to confirm and close the case with the client, and this involves transmitting all the recordal evidence for each jurisdiction. And again, here, this is kind of experience-based, because the recordal evidence really depends on each jurisdiction. So basically, this is what we do with this project management approach, and the idea is really to anticipate a maximum on all possible issues to make sure there is no surprise along the way, and especially what we want to avoid, and they do not appear here, we want to avoid office actions post-filing recordal. So this is what our intention with this, and actually we have very few of them, because we are able to really clarify what the status of the IP rights, what is the status of each IP right during the data verification process. If you move to the next slide now, Sharon, basically what we offer, and I think what makes this kind of project successful is actually people familiar with these processes. When I compare this with an IP firm, or I used to work in-house as in-house European patent attorney, we don't do this on a regular basis, and this is actually an issue, because if you don't do this on a regular basis, you don't know the specificities of each jurisdiction, and you don't know what are the issues that may come up, and this is actually what we bring by doing this all day long. This is very important. We're also quite solution-oriented in the sense that if something comes up, when we will try to solve the issue with our agents so that we come back to the client with a solution, which can be an issue in some cases. So I already mentioned we have agreed on specific fees with our agents, which are based on volume, not only on a volume for each IP right, but also on the fact that we work with these agents on a very regular basis. Project management, I mentioned this already. We have a lot of quality control during this process. Actually, the quality control is essential because then you send documents which will be rejected by offices if you don't make sure they have been filled in properly and executed properly as well. Very quickly on the upstream data verification, we've insisted a lot on this, so I don't insist too much. The supporting documents is really something where we can also bring value because we know which documents are accepted. We can facilitate, for example, translation issues by preparing bilingual forms. We can generate POAs also, which also comply with all legal requirements. And finally, which is also a burden and sometimes a surprise for people not familiar with this, is all these notarization and legalization requirements, which are often a burden and that we try to simplify because we can do this for you, especially after the notarization process. For US companies, I know notary publics can sign documents relatively easily, but legalization is more burdensome, and we can help for this as well because we can do the legalization on our end. Just the next slide is a summary of the added value we can bring. Since it's almost time, and I think I've addressed almost most of this, I propose that we have a small Q&A session, Sharon, if you want.
Well, thank you, Yannick. I think that's right. Well, we have a lot of questions. We had a lot of attendees today ask some questions. So I'm going to pick a few because we are at our time, but I thought it would be a good idea if we can cover a few because some were asked for more than once. So this is directed at Ken. Ken, the question is, if you set up an escrow account to budget for those recordal process, whose budget does it come out of? Should both the buyer and seller contribute to the escrow account at or before the closing?
No, it really does depend on who you're acting for, obviously. If you're acting for the buyer, then typically buyer has the obligation to record the assignments. And so buyer in a deal would already have an account open to deal with due diligence issues, associated costs with the due diligence and the closing. And it is out of this account that is fairly easy to set up an escrow. In the alternative, obviously, if you're part of an IP department that has a separate IP department budget to handle such mergers and acquisitions, if you're a large company that do this on a regular basis and you have budgeted for it, then certainly you can take it out of that account as well. If you're a seller, similarly, you would have an account set up to sell this entity, and for whatever reason, if it fell upon the seller to handle recordals, certainly an escrow can be set up. Again, it very much depends, but if you're dealing with a buyer situation and you have to record, the buyer would set up the escrow.
Thanks, Ken. We have another question here, and this is directed at Yannick. The question is, this is regarding transferring the EPO at the EPO more than 9 months post-grant. Will the EPO not record the transfer, or will they not update the register with the new owner? We were just discussing this in my office, and I could use the clarification.
So actually, I hope you hear me. Yes, this is a very good point, actually, and I can imagine from a US standpoint that it's not so obvious. But basically, as you already know, I mean, the European patent process is central until grant. And actually what happens after this is that you can still file an opposition within 9 months. Actually, if no opposition is filed, then the register of the EPO is closed at 9 months. Or if the opposition proceedings are launched, then the register is still open. So until the opposition period has passed or the opposition proceedings are closed, the register is open. However, you cannot register anything on the EPO register after this period has passed. You have to go at each national office where the patent was validated, and you cannot do otherwise. And there I come back to Phil's point on the different requirements, because the requirements across Europe in countries like Austria or Italy, etc., are very burdensome. And some jurisdictions make it simple. I can think of the UK, for example, where the process is quite straightforward. But typically in Austria, Poland, Italy, these are really difficult jurisdictions where you need notarization of documents, legalization of documents. Each stage should be properly documented. Otherwise, the office will simply reject the recordal process. And these recordals must really be performed at national level in front of each national office of the European Patent Convention member states.
Thank you. We have another question. This is directed at Mark. The question is, you mentioned a 3-month target for U.S. recordation.
Sharon?
Yeah?
Sharon?
Yes?
I just want to add something which we discussed with Phil during the preparation,
Oh, I'm
which I
sorry.
think is important.
Go ahead.
Is the fact that if the unitary patent comes in, which is something that is planned in the coming months, hopefully, then these unitary patents will be centralized at the EPO, and there will be a register for the unitary patents. And therefore, for unitary patents, if I go back to the question which was asked, for unitary patents, there will be a register for these unitary patents where such recordals will be possible well after the opposition period, if they ever come up.
Great. Thanks for the clarification. This is a question that came up, and this is for Mark. You mentioned a 3-month target for U.S. recordation. Is that a hard deadline or a suggestion? Are there negative repercussions for not recording within 3 months in the U.S.?
Yeah, thank you, Sharon, and thank the questioner. And the 3-month date comes really from the MPEP section 301, where there is a presumption that the recordal is effective on the date of the assignment if the recordal is filed in the patent office within 3 months of the assignment date. And so it's just a presumption, and it's not a hard and fast rule. So, but it does bring up the issue that when you're filing in the U.S. Patent Office, you want to make sure that you have all of the information on the EPAS cover sheet filled out. You know all that information so that the assignment becomes effective, and you've got then your attachment to the EPAS cover sheet, and so that the recordal is effective, and that the chain of title then is continuous.
Thanks, Mark. All right, one more question, and this is directed at Phil. Phil, this is the question. If an opponent at the EPO wants to transfer their opponent status, how is that done in practice?
Thanks, Sharon. So your status as an opponent at the EPO cannot be transferred freely in the same way that a patent or patent application could be transferred. But the EPO does allow it in some situations. For instance, if upon the death of the opponent, the status can transfer to his or her heirs, or after the legal incapacitation of a company. So basically the principle of universal succession applies. There's one other situation when you can transfer opponent status as well, and that's if the opponent status is transferred as part of business assets that relate to the opposition. So if you imagine a company with various divisions, if that relate to different technologies, for instance, if the opposition was filed in relation to one of those divisions and that part of the business is sold, then the opponent status can be transferred in that deal, but the agreement would need to set out that the opponent status was being transferred. That contrasts with the situation where you have a parent company and separate subsidiary companies. If the opponent is the parent company and a subsidiary is sold, but the subsidiary was itself a legal entity that could have filed the opposition, then you can't transfer the opponent status of the parent along with the subsidiary. So ultimately, you record the transfer of opponent status in the same way in writing, requiring the signatories of the party submitted to the EPO, but that opponent status isn't as freely transferable as a patent or patent application.
Thanks, Phil. Well, I appreciate everyone's patience. We went over a little bit of our time to get some of these questions in. Do know that all of the questions that have been submitted, we will follow up with those folks and answer those questions specifically. And I want to thank the panelists for being part of our IP exchange today on recordals. I think it was really valuable, and a lot of good ideas and information are exchanged. And really thank you to all of the attendees for your attention and for your questions. And I appreciate that you let us go over just a little bit so that we could get some of your questions answered. So with that, I'll close out and wish everybody a good rest of your day.